Hello and welcome to Jew Research Academy's YouTube channel. Today we'll be discussing a very important Supreme Court judgment in the case of Shilpa Sailesh versus Varun Srinivasan. This case analysis is especially important for people who are preparing for CLAT PG or similar exams where the knowledge of recent judgments is tested. So let's start with this case and understand a few very important things about it. So first is this is a constitutional bench judgment. So naturally it is a very important case because it has been decided by a 5-judge bench. This came out in May 2023. It's a very important judgment under family law because in this case, the Supreme Court was talking about a ground of divorce, which is irretrievable breakdown of marriage, and the power of the court, especially the Supreme Court, in giving divorce on this ground. So let's come to the main issue of this case. So in this case, the primary issue is that Section 13B of Hindu Marriage Act, which talks about mutual consent divorce. So mutual consent divorce has a procedure. So in this procedure, the first petition has to be presented by both the parties saying that they want to take divorce, and then the second petition has to be filed under Section 13B, for which there is a cooling off period of 6 to 18 months. So the issue in this case is that whether this cooling off period of 6 months, as is mentioned in Section 13B, is it mandatory or directory? So it means that whether it can be waived by the Supreme Court or not. So here the Supreme Court was particularly talking about the power of Article 142. So the issue is whether this mandatory period can be waived off by the court in the exercise of power under Article 142. Now the conflict arises because of these 3 judgments. So in the case of Neeti Malviya versus Rakesh Malviya, the court differed from the judgments of the Anjana Kishore and Manish Goyal case, in which the court held that Article 142 can be used to waive off the 6-month period under Section 13B of Hindu Marriage Act. So whereas Neeti Malviya said that the court cannot use this power, Anjana Kishore and Manish Goyal were of the opinion that Supreme Court can use the power of Article 142. So that is why the case comes before a 5-judge bench for a final resolution on the extent of power of Article 142. Now let's quickly look at the legal provisions. So since we are talking about Article 142 and the power of Supreme Court, let's take a look at it. So Article 142 talks about the power of Supreme Court for enforcing decrees and orders. So 142 clause 1 tells us that the Supreme Court can pass any decree or any order for doing complete justice in any matter pending before it. So this term complete justice has been interpreted very widely by the court, and in this case the Supreme Court is relying on this very aspect to look into whether this period can be waived off or not. Now, since we talked about 142, let's also take a look at Section 13B, which talks about divorce by mutual consent. So 13B2 talks about the second petition, and it tells us the time in which this petition has to be presented. So clause 2 says that when both the parties will make the second petition, it cannot be earlier than 6 months from the date of first presentation of petition and cannot be later than 18 months. So the primary issue here is that this term, not earlier than 6 months, can the court waive this 6 month of waiting period or not? So now let's see what the court has said. So the first thing the court said is that irretrievable breakdown of marriage is not statutorily recognized. So if you look at the Hindu Marriage Act, you will see different grounds. There are different fault grounds like cruelty, adultery, all of those. And then there are some other grounds like mutual consent divorce, which have been recognized under the Hindu Marriage Act and under other personal laws as well. But the ground of irretrievable breakdown of marriage is yet to be recognized by the legislature. So the court very clearly says that this is not statutorily recognized yet. But the court also said that Supreme Court can still dissolve marriages on this ground under the very wide power of Article 142, which empowers the court to do complete justice. The next important things which were said were with respect to Section 13B of the Hindu Marriage Act. The court also said that this waiting period of 6 months, which is also known as the cooling off period, because the intention of giving these 6 months is to allow the parties to cool off, to see if they still want to get the divorce or not. So the court said that this period can be waived off, again under the power of Article 142. So the court finally said that the grant of divorce on this ground, that is the ground of irretrievable breakdown of marriage, is not a matter of right, because the power under Article 142 is discretionary and it depends on when the Supreme Court feels it fit to be used. So let's finally come to the decision of the court. So finally the court said that divorce can be granted on this ground, which is still not statutorily recognized, but this can only be done under Article 142 of the Constitution of India, which means only the Supreme Court can do it as of now. Next thing the court said is that the cooling period of 6 months under Section 13B can also be waived off under Article 142. But the court also said that petitions cannot be filed under Article 32 or 226 as writ petition for seeking divorce on the ground of irretrievable breakdown of marriage. Because as we know that writ jurisdiction can only be invoked for the Supreme Court in case of infringement of a fundamental right. Lastly, the Supreme Court also clarified that this remedy of divorce on the ground of irretrievable breakdown is only a discretionary remedy under Article 142. So this sums up the case for you guys. If you like this video, please like and share and subscribe to our YouTube channel.